And how the justices have framed the questions in this legal argument suggest that there may be more at stake than simply gay marriage. The Legal Intelligencer's Gina Passarella reports.
On April the 21st, 1975, Richard and I were legally married in Boulder, Colorado.
There was nothing in the Colorado Marriage Code that would prohibit me from issuing a marriage license to two people of the same sex, so I did.
Tony is an Australian citizen. He is seeking to be permitted to stay in this country as the spouse of an American citizen.
In 1975, long before the term gay marriage became part of America's vocabulary, Anthony Sullivan and Richard Adams applied for and were granted a license to marry in the state of Colorado. When authorities challenged that union, a young judge ruled that Anthony and Richard could not stay together as married in the United States. History tells a story of great irony, because that judge would someday play the most pivotal of roles for LGBT rights across the country. The American history of gay rights, from Kinsey's studies to the New York Stonewall riots to San Francisco politician Harvey Milk, is inextricably bound to the Supreme Court. In the late 1950s, the U.S. Postal Service refused to deliver a gay bisexual magazine known as One, the FBI claiming it obscene. The Warren Court took the case, overturning two lower court decisions and marking the first time the Supreme Court ruled in favor of homosexuals. But that would be the last decision furthering gay rights for almost 40 years.
The history of the treatment of same-sex couples has evolved tremendously over the last several decades. In 1972, the Supreme Court actually reviewed a same-sex marriage case. It was a case called Baker v. Nelson. Two men had tried to obtain a marriage license in Minnesota. The Supreme Court dismissed their case outright in a one-sentence opinion that just said there's not even a federal question here, right? That the idea of same-sex marriage was so fundamentally sort of absurd to the court. You then fast forward to 1986, right, to Bowers versus Hardwick, which isn't a marriage case. It's a case about the right to engage in same-sex sexual conduct. A gay man who had literally been arrested for having sex with another man in his house. In 1986, the Supreme Court found that that was perfectly fine.
By the 90s, there was a hint of change. Hawaii considered legalizing gay marriage, but only briefly. Even the election of Democrat Bill Clinton didn't help the LGBT community much, at least legally.
One of the interesting things about gay marriage is that in 1996, Bill Clinton passed DOMA, the Defense of Marriage Act, saying marriage should just be between one man and one woman. So when you look at the time frame from 1996...
But then enter Supreme Court Justice Anthony Kennedy, the same Anthony Kennedy who 20 years earlier, as a Colorado Circuit Court judge, denied Anthony Sullivan and Richard Adams the chance to stay as a married couple in the United States. A Reagan appointee, a conservative judge, but apparently, by the 1990s, not so conservative on certain social issues.
Justice Kennedy has really staked his legacy on building these cases around gay rights, starting with Romer versus Evans in 1996, Lawrence versus Texas in 2003, United States versus Windsor in 2013. All of those decisions are pro-gay rights.
Really a watershed moment for LGBT people. Justice Kennedy's three sort of LGBT-friendly opinions.
Kennedy wrote the majority opinion in all three cases, overturning anti-gay statutes, ending sodomy laws, even rejecting Bill Clinton's Defense of Marriage Act, and leading to the landmark case now before the High Court.
So the Supreme Court's going to have to make a determination as to the constitutionality of a gay couple marrying.
I think it pretty much is a foregone conclusion that they're going to say, yes, there is a federal constitutional right to same-sex marriage, and that's going to apply in all 50 states.
And while I love Justice Kennedy, and they joke that he loves two things, gay rights and states' rights.
Which may explain why the questions posed by the court in this case are framed as state duties, not as equal rights protections or due process, leading some to believe the Roberts Court, through the voice of Justice Kennedy, will further safeguard gay rights, but only as it relates to marriage.
He did not go the route of saying that sexual orientation is, like sex or race, a protected class. And there's a lot of advocates, including me, who think he should go that route. The federal government doesn't have anti-discrimination laws around employment. Discrimination in housing, in schooling, that is allowed in most places in this country and is not banned by federal law. So marriage is coming before those advancements, which still need to happen.
Many legal scholars believe that same-sex marriage will be a reality in all states by the end of this term, courtesy of the Roberts Court. That collective sigh of relief you hear may not just be from the plaintiffs in the cases, but from family law practitioners who will finally have a uniform definition of what constitutes a valid marriage in the United States. For the American Law Journal, I'm Gina Passarella.